Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
We will go on the record in the matter 25 CT04, State of Wisconsin versus Charlotte Caldwell. The state appears through Assistant District Attorney, through District Attorney Kevin Schmidt in person. We have Joel Feliski, Defense Counsel in person, along with Ms. Caldwell. We're set here today in this matter for a plea and sentencing. Mr. Feliski, do you have a plea questionnaire waiver of rights form?
I do, Your Honor. Ms. Caldwell has agreed to plead to count 1 of the complaint. The remaining counts will be dismissed and read in. The parties are making a joint recommendation for sentencing under IDIP guidelines. It's my understanding that the IDIP coordinator, Ms. Tessa Anderson, did receive confirmation from Ms. Caldwell regarding her satisfaction of that program. And I do have a completed plea questionnaire. May I approach?
You may. Head up, please, sir.
Oh, sorry.
Has she sat 48 consecutive hours?
I don't believe so.
So she would be reporting today?
Yes, Your Honor.
That's the agreement that you've reached, Ms. Caldwell?
Yes.
So I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes, Your Honor.
Did your attorney go over this document with you thoroughly,
Yes.
essentially word for word,
Yes.
and you understood everything on this document?
Yes.
Is that your signature on the second page?
Yes.
You are pleading guilty to 1 count of OWI third. You are 29 years old. You have 12 years of schooling. You can read, write, and understand the English language. No drugs, alcohol, or medications, and no mental illnesses or disorders, correct?
Correct.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties and the minimum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on this document. Did your attorney thoroughly go over those rights with you?
Yes.
And do you understand them completely?
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that the state would have to prove as to count 1, operating motor vehicle while under the influence, a third offense, that on or around January 17, 2024 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, and this will be your third countable offense. Do you understand what the state would have to prove?
Yes.
Do you understand that the maximum possible penalty could be a fine of not less than $600, but no more than $2,000, and imprisonment of not less than 45 days, but no more than 1 year in the county jail?
Yes.
Do you understand that upon conviction, the court shall also revoke your driving privileges for not less than 2 years, but no more than 3 years, and shall order you to submit to an alcohol or OWI assessment and follow through?
Yes.
Do you understand that there is an agreement presented to the court in which both sides are recommending the court follow the IDIP, Intoxicated Driver Intervention Program guidelines? Do you understand that I'm not bound to follow that?
Yes.
Said differently, I could sentence you all the way up to that maximum penalty if I thought it was warranted. Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Now, did you go over the criminal complaint with your attorney?
Yes.
In particular, this section that's called the probable cause section, where it basically says what happened that day and why you were charged with the crimes?
Yes.
For the most part, are those facts accurate?
Yes.
Are you pleading guilty to an OWI third because you are guilty of that offense?
Yes.
Are you admitting here today that you in fact did operate a motor vehicle on a highway or roadway of this county and state while under the influence of an intoxicant?
Yes.
Mr. Feliski, may the court use the probable cause section of the criminal complaint along with the statements made by your client to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing?
Yes.
And voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yes.
Did he discuss with you a potential for any defenses or a lack of defenses in this case?
No.
Well, did he talk to you about the discovery and what happened that day?
Yes.
And did he say, well, based upon this, we may have the defense if we go to court or go to trial about this or that?
Yes.
And did he say, I'm not seeing that you have a defense or your defense could be weak or strong?
Yes.
Okay, so you are satisfied?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
As to count 1, OWI, third, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I will find you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. I will dismiss and read in count 2. Count 3 will be dismissed and merged in with count 1. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
This is a OWI in the high range. The BAC when the blood came back was 328, which is very high. This person's criminal history is just other OWIs, this being the third one. The email from Tessa Anderson indicates she did the equivalent in another location. She appears to be a Minnesota resident. So doing the IDIP equivalent here is appropriate because it incentivizes drivers to do the things required, which included the driver safety plan, which the email from Tessa Anderson said she did the equivalent for already. Thank you.
Thank you. Mr. Feliski.
Thank you, Your Honor. Your Honor, this case is a bit of a soft spot for me. This was actually the first case I was assigned when I came onto the SPD. I've worked with Ms. Caldwell since I began my time here, and throughout my time here, she's been responsive to all of my questions of her. She's followed through on what I've asked of her. She's been engaged with this entire process. And I do want to emphasize, Your Honor, that she has wanted to resolve this matter. She actually entered treatment of her own volition. I didn't ask her to. She just knew that this was something that she had to address. I think she acknowledges that this is at its core a substance use issue. It's a shame that it had to get to an OWI 3, but she has put her best foot forward, both in going into treatment, graduating and completing treatment, engaging in some mental health follow through at the recommendation of that treatment, along with completing the IDIP guidelines. The only delay that has come from this process has just been because Ms. Caldwell is a sole provider for her child, her son, who's actually here today. She is a single parent. So I think that it says a lot about her that she has been willing to engage in this programming at her own expense, because she acknowledges that she wants to be accountable here, take responsibility, and put her best foot forward. I think that this is an appropriate agreement. I think it protects the community. It will help address Ms. Caldwell's needs. It already has, and it will continue to do so going forward. And I think it is appropriate given the nature of the offense. I would ask the court to follow the agreement. Thank you.
Thank you. Ms. Caldwell, do you care to make any statement here today?
I mean, Joel pretty much cleared up everything I would have said myself, just saying, I've been doing everything I can to, take accountability for my mistakes and do my best to follow treatment programs, to take care of my substance abuse issues, and just trying to make sure I can work around and do everything I can to continue being a parent and continue being an active member of society out here, and just continue working and doing my best for my life and my son's life.
Good. I'm glad to hear that. Ms. Caldwell, I'm sure Mr. Feliski has told you this, or maybe you know this already, but in OWI 4, if you get another one, lifetime revocations, lifetime. The only potential of getting an ability to drive again would be after 10 years, and it's very difficult to do. You have to show this, that, and the other in order to only get an occupational driver's license. So it's very, very difficult and hard. So it's something that you need to consider and think about anytime you're out, anytime you have any alcoholic beverages, because if you do drive and you get an OWI 4th, that's it. And as a young parent, as a person who needs to get around a very rural county, you need your driver's license.
Right.
So it's very, very important that you have that on your shoulder at all times if you are engaging in any consuming of alcoholic beverages and you need to drive or you drove. OWI force or thirds, any OWI is extremely serious because it puts not only you at risk, but the public at risk of serious harm or death or injury. You had a very, very high blood alcohol content, a 0.328. That's extremely high. That could be on the verge of alcohol poisoning. I'm very glad that you went through the IDIP program. I know that program does a lot for the individuals that participate in it, and you learn a lot and you go forward and you already do the OWI assessment and that driver safety plan. So you're already ahead of the game by the time you enter a plea. I think that is such a great thing that you participated in this and you took it seriously, and you are resolving this case in a relatively short amount of time. Kudos to you on that. It tells me that you do take this seriously and you want to put this behind you and you want to move forward and you want to focus on yourself, your son, and your sobriety. I don't know if you have an alcohol issue such as you would classify yourself as an alcoholic, but if you, again, are going to engage in consuming alcoholic beverages, do so safely. I don't think that you're a risk to the community when you understand these things and when you engage in a program like this. So I do think that following the recommendation is appropriate, and so the court will do so. It's going to be a significant fine attached with all of this due to the blood alcohol content. Significant fine. And that is unfortunate for a working mom or young mom. The court will order that there will be $3,175 in fines and fees, plus a $10 blood draw fee, 55 days of jail, 24 months revocation of your driver's license, 24 months of ignition interlock device. Again, you're ahead of the game. The court will order that you turn yourself in immediately to the jail, that you sit at least 48 consecutive hours in the jail, because that's what the law requires. Mr. Feliski, are you arguing for monitor?
Yes, Your Honor. As I had said, Ms. Caldwell is a single provider. She is I believe she has sole custody of her child.
I do share with my son's dad. We have our own personal agreement that we stick to where I have him most of the week because he goes to school with me and then he goes with his dad on the weekends when he's not in school.
Okay. I don't think that you would be a risk if the court does grant the monitor. I think it's something that you need, and you will be tested daily with regards to any alcohol consumption. So along with that I will grant you the ability to serve on electronic monitor at your cost, and it must be prepaid in 30-day increments at a time. Ms. Anderson should have told you that, and you would work with Dave Hatch to get yourself connected to that monitor. I'm going to warn you that you may not have anything alcohol related or has alcohol fumes. Even rubbing alcohol will set off the machine. If you eat anything that's made with alcohol, such as, a tiramisu or cherry jubilee or, chicken marsala that has actual alcohol in it when it's made and the alcohol is not completely burned off, and you blow hot, meaning you blow positive on the machine, you will immediately be told you're revoked and you must return to the jail to serve the rest of your sentence without good time and without Huber. I do not listen to arguments of, this was rubbing alcohol. I had this I was near the gas pumps when that's why it went off. I don't accept those arguments. So be very, very careful what you're around when you have the machine. and you blow into the machine. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do have some of your money paid down, but you're going to need to pay a significant amount remaining in the fines and fees. Do you need a payment plan?
Yes.
How much do you receive in any kind of funds a month?
Right now I'm only working 2 days a week. I'm currently trying to find another second job to make the ends meet. So right now I'm only making like 150 a week. So like a total of 600 to 700 a month right now.
And do you receive any per cap or any other kinds of payments, child support, anything?
I get $100 in child support, no per capita.
What the court is going to do is I'm going to order $150 a month to be paid towards your fines and fees. If you do have a significant hardship and you cannot afford the $150, you would need to have a hearing in front of me and fill out a form to show me all of your expenses and all of your income. I'm going to warn you, though, that sometimes people come in saying, I want to have it amended down, modified down because I can't afford it. And the court reviews all of that information along with testimony. And there's been various times I've actually increased the monthly payment. So be very sure of what you're asking and why. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I'm ordering you to provide your DNA. So you're going to go report to jail, serve your 48 consecutive hours. They will take your DNA. In a case like this, you may be able to have it expunged through a written letter to the Department of Justice, not to the court, but to the Department of Justice. And that simply deals with your DNA in the system. I believe that covers everything, Mr. Schmidt.
Nothing from me.
Mr. Flisky?
I believe she has 1 day of jail credit, Your Honor.
All right, 1 day of jail credit. And then again, you will need to sit that 48 consecutive hours. That 1 day does not go towards that, but it will come off your total amount to sit. Okay. All right. Anything further?
Nothing further.
Thank you. Then we are adjourned. Are you switching? No. Okay.